Greetings to everyone present. My name is Ankit Malhotra. I am a Felix scholar from SOAS. I read my LLM in international law over there, and now currently I work as an associate in the Chambers of Justice A.K. Sikri, who's an associate member of FOPAM Court and an international judge in the Singapore International Commercial Court. He is also a former Supreme Court judge here in India. This paper was actually born out of a discussion with Justice Sikri, whose interest in international law is paramount and perhaps also surpasses mine. With those opening words, I also want to discuss this case and also perhaps touch upon the significance of the case, which represents the pivotal juncture in the annals of international law, because it exemplifies the nuanced challenges that arise with the traditional legal frameworks that are applied to the complex scenarios of modern geopolitical conflicts, specifically involving non-state actors and asymmetric warfare strategies. The engagement with non-state actors in conflict also introduces significant legal complexities, as those groups do not fit neatly in the traditional paradigms governed by international law. This has historically been linked with state actors as well. This case also highlights the intersection of various human rights violations, specifically those relating to terrorism, financing, and radical discrimination. And these are, of course, all enshrined in the economic, social, and cultural rights that this essay seeks to discuss. The intersectionality of these rights is also explored in the case that we have to discuss, as it underscores the evolving role and nature of international human rights law, as pointed out by famous scholars such as Philip Alston, amongst others. The case also signifies the importance of the current geopolitical tensions between Russia and Ukraine, and in doing so, the application of the International Convention on Suppression of Financing of Terrorism and the International Convention on the Elimination of all forms of racial discrimination are of seminal importance. They also discuss and highlight the precedents in recognizing and addressing the multifaceted approach and nature of conflicts that traditional racial and geopolitical boundaries can not perhaps possibly understand. But what about the background of the dispute and where we stand as of now? On the 26th day of February 2022, just 48 hours before subsequent assaults perpetrated the Russian Federation and the Ukrainian capital, Ukraine lodged an application initiating proceedings against the Russian Federation before the ICJ. The application marked the inception of all cases in such matters, the crux of the dispute delineated as per- perpetrating the interpretation, application, and fulfillment of the 1948 Convention on the Prevention and Punishment of the Crime of Genocide. Notably, Ukraine chose not to predicate its claims on the prohibition on the use of force as enshrined in Article 2.4 of the UN Charter, which might have been appeared as a more punitive and effective measure. The strategic rationale behind Ukraine's invocation of the interpretation and application of the Genocide Convention lies in its relevance to both the conflict's backdrop and the issues of jurisdiction. But in addressing the issue first, the justification put forth by the Russian Federation for initiating attacks on Ukraine following weeks of high tensions and unsuccessful negotiations was the alleged perpetration and mass killings of genocide against individuals of Russian ethnicity in Donetsk and Luhansk. Additionally, Russia also cited Article 51 of the UN Charter to rationalize its use of force, contending that it was acting in self defense to safeguard the populace of Donbass from the purported genocide. This assertion of collective defense was further predicated on Russia's acknowledgement of the autonomy of the two regions, designated as the Donetsk People's Republic and Luhansk People's Republic. In its submissions, Ukraine asserted, amongst other points, that the Russian Federation had erroneously alleged the occurrence of genocide in Luhansk and Donetsk Oblast of Ukraine, a claim that was refuted and then further contended that Russia lacks any legal justification to intervention in and against Ukraine with its aim of preventing and punishing any genocide. Ukraine petitioned to the court to affirm that declare that assertions made on such nature were not meeting the definition of genocide as outlined in Article 3 of the Genocide Convention. It also affirmed to declare that Russia has not authorized under the Genocide Convention to undertake any such action with or against Ukraine with the objective of preventing or penalizing alleged genocide. It also asked the court to affirm and acknowledge the independence of Donetsk People's and Luhansk Republic as predicated on surplus claims of genocide and therefore lacks foundation in the Genocide Convention. The court also the court was also asked to determine the special military operation as declared by the Russian Federation on and after the 24th of February 2022 is grounded on baseless claims of genocide, thus lacking foundation in the Genocide Convention. It also asked the court to mandate that the Russian Federation furnished assurances and guarantees of non-repetition, pledging not to undertake any unlawful actions without or against Ukraine. And finally, it asked the court to request and direct the Russian Federation to provide complete reparations for all harm inflicted on any human beings in such matter. The request put forth by Ukraine delineated the two primary concepts. Initially, the court asked and urged to issue an adverse declaration on such matters, affirming the absence of any genocide perpetrated by Ukraine. Secondly, a constructive determination was sought, asserting that the Genocide Convention prohibits restoring military measures to forestall genocide. In order to establish jurisdiction, the court went as far as to argue that under Article 36(2) of the statute, such measures can be adopted and recognized. It was also invoked in Article 9 of the Genocide Convention, to both which Ukraine and Russia were parties. Pursuant to this, it said the dispute between the contracting parties relating to the interpretation or application or fulfillment of the present convention, including those relating to the responsibility of a foreign state for genocide for any other acts enumerated in Article 3, shall be submitted to the International Court of Justice at the request of any of the parties. That, and I quote further, there is a dispute between the two existing parties. Number two, the dispute pertained to interpretation of the application of Genocide Convention, as all contested parties' aspects were linked to Russia's allegations of genocide against Ukraine, were invoked as a legal basis for taking harm and action. While the Ukrainian approach was somewhat innovative, it was nevertheless was not the first instance where Ukraine was employing the strategy in a dispute against Russia. Following the annexation of Crimea in 2017, Ukraine had filed a lawsuit against Russia alleging violations of the International Conventions on Suppression of Financing Terrorism and the International Convention on Eliminating All Forms of Racial Discrimination. The court goes far as to order provisional measures or procedural objectives, and under Article 41 of the statute, read with 73, 74, and 75 of the Rules of Court. Pursuant to these measures, the court is empowered to prescribe, if it deems necessary, any interim measures that should take safeguards presenting the rights of the parties. The plea for provisional measures takes precedence over all other cases and notifications and is provided promptly to the Security Council. Ukraine urged the court to mandate that all immediate steps should be taken to halt Russian military operations initiated on the 24th day of February in 2022. In its oral hearings, it is representative that the climate of such measures in 1945 since Europe have not been seen. They were also alleged that causing huge human suffering, including widespread commission of war crimes, displacement of millions of civilians, and such measures were of significance. Lastly, Ukraine had also asserted that the adverse effects and environmental consequences of such assaults are particularly attributable to Russia's neglect of nuclear safety protocols and the deliberate targeting of fuel depots, resulting in the result of vast clouds of smoke and into the atmosphere. In addition to the loss of life, the displacement of thousands of individuals from their homes and the resultant of the environment degradation constituted irreparable harms, necessitating immediate action. The Russian position thereby held that the court lacked its jurisdiction on the case, thereby precluded the consideration of the claim even at provisional measures. Russia concluded and therefore argued that it indicated its abstention but submitted a letter. And in such a letter, it asserted that, contrary to the Ukrainian submissions, the case could not be construed under the 1948 Convention on Genocide. It argues that there are two key points that need to be kept in mind. Firstly, Ukraine was effectively challenging the legality of Russian use of force, which fell outside the purview of the court's invocation of the convention. And secondly, that the special military operation orchestrated by Russia was not predicated on the convention, but was rather on the right of collective self defense, as enshrined in Article 51 of the UN Charter and customary international law. President Putin's reference to genocide were deemed general and insufficient to establish a solid basis for framing the dispute within the Genocide Convention. At best, Russia's allegations of genocide violations alluded to customary international law norms on the subject. In essence, from the Russian perspective, there existed a dispute regarding the interpretation and application of the convention. Consequently, there was no viable means of framing a case within the jurisdiction of the ICJ. The court therefore neither provided provisional measures nor rendered a decision on merits according to Russia. Therefore, what becomes important to note is what actually was noted by the court in its substantive legal arguments, because what it therefore does is that it notes the Russian absence from the oral proceedings and has emphasized that non participation does not undermine the legitimacy of the court's ruling or impede for the imposition of interim measures. It therefore notes that the absence, formally pursuant to Article 49 of the statute of the court, expresses that a party's absence might negatively affect the judicial process by depriving the court of judicial cooperation and contribution. Russia's previous participations in the ICJ suggest a broader disengagement from international bodies amidst the 2022 conflict. Despite these unconventional nature of Russia's participation through a letter, the court valued the input, stating that the importance of understanding the position of all involved parties is important. The court therefore confirmed that in its initial jurisdiction over the case, based on several factors, like the matters initiated by Ukraine on such issues, any resolutions under the convention and signatories to the Article 9 of the convention are important. Russia's invocation of self defense under Article 51 of the Charter as justification from its actions did not detract from the court, as the court noted that a single act or omission could fall under multiple treaty obligations. As for this instance, the court acknowledged that since 2014, various Russian state entities and high ranking officials have accused Ukraine of genocidal acts in Luhansk and in Donetsk and regions in official discourse from the UN Forum members. What therefore needs to be noted on such matters, especially on merits, is that it initiated an analysis by expressing significant concerns over the Russian Federation's use of military force in Ukraine. This is done so by highlighting the grave implications under international law and the UN Charter, along with other important international conventions that are discussed under this paper. But what is important is an assessment of the case and the discussion on merits that follows, for that provides an answer to the plausibility test, which the court found as able to determine the plausibility of the actions and the support that a contracting party may unilaterally exercise military force on another territory to prevent or punish purported genocide, considering the convention's aim and objectives. This is crucial and also merits a detailed discussion, since the court had previously emphasized in other cases that the states must adhere to international law in their efforts to prevent genocide, stating that, and I quote, every state has or could only act within the limits provided by international law, end quote. And this is found reference in an application on the Convention of Prevention and Punishment of the Crime of Genocide in the Bosnia-Herzegovina versus Serbia and Montenegro matter, which dates back as far as to 2007. But the court also mandated that the Russian Federation suspend all military activities initiated in 2022 on the 24th day of February until the court reached its final decision. It further required that military action or irregular units, as well as these entities beyond the Russian control, should be requested to stop their charge. However, the court declined Ukraine's request to compel Russia to report on compliance with these orders within a week. This left the implementation of provisional measures without formal oversight. Lastly, the court was also instructed at both parties to avoid any actions that would worsen or complicate the dispute further, while some judges, like the American Judge Robinson and also the ad hoc judge, Judge Dode, argued that this non aggravation order should have directed solely at Russia, that the court opted for a more neutral stance, potentially reflecting a strategic and balanced approach to prevention and escalation of hostilities, which underscores the court's commitment to fairness and equity in the procedural stage. What therefore is required to study the broader implications, and the implications we stand at the intersection of human rights and the violations that they seek. For that remains the much more potent and enforcement mechanisms study. And in this respect, one is reminded of the Legrand case, which noted that it classified that the orders of provision measures are indeed binding, despite the language of the statute, which uses the term indicate in these measures. It is important to recognize that under Article 94 of the state statute, all members of the United Nations must adhere to the decisions of the court. This article also obliges the victorious party to bring instances of non-compliance to the attention of the Security Council, which can then decide upon the actions accordingly. Despite this, it has been argued that provisional measures are enforceable or not is solely dependent on the matter per se. Nevertheless, the precedent set by Legrand supports the case on enforceability measures. However, the effectiveness of the Security Council in enforcing measures against members of the Permanent Five are also needed to be noted. But this is not without precedent. For in the Nicaragua versus United States of America case, the ICJ found that the United States had breached international norms regarding the use of force and non intervention. The US therefore then voted the Security Council's enforcement of the decision. Consequently, a question of enforcing decisions of Ukraine versus Russia is not presented to the Security Council, potentially to avoid undermining the court's authority, thereby a veto by the defendant state. A potential resolution could involve leveraging Chapter 5 of the UN Charter, which focuses on Article 36, which states, and I quote, recommend appropriate measures or methods by adoption and adjustment, taking into account previously adopted measures of dispute resolution under Article 27.3 of the Charter, which suggests that parties involved in the dispute must abstain from voting in the Security Council in the dispute. Therefore, the term recommendation decisions under Article 6 of the Charter of the Security Council have been deemed binding by the ICJ. While other orders remain unfulfilled, Russia's compliance constitutes a breach of international law, making it liable for all resultant damages. The decision of the court in 2022 in March holds the symbolic significance of the ICJ's decision, which now makes it virtually impossible for everyone, including Russia, to deny its illegality. Notably, the order was also issued in a context where the use of force was not the primary use of consideration, thereby underscoring the judiciary's vital role. The court, in executing its contentious function uniquely amongst UN bodies, issued a binding decision during the conflict. However, the executive scope of what parties can request in international proceedings and what an international court mandates concerns provisional measures are of two different natures altogether. And at this junction, I would like to discuss the implications of such practice on the general practice at hand. Because the Russian aggression under Article 9, which pertains to the interpretation, application, or fulfillment of the Genocide Convention, suggests by the past rulings of the court under the Bosnian case highlighted above, indicates that Article 9 does not extend to breaches and obligations beyond the Convention's control. Since the court avoided making automatic connections between international use of force and genocide, emphasizing that casualties from conflicts does not equate to international use of force or genocide as covered under international humanitarian law. The case of Russia versus Ukraine is distinct, as it was Russia that claimed genocide justification for its actions. Ukraine was therefore aimed to clarify the genocide laws and the use of force are separate and therefore false and should be rejected. The potential strength of the order lies not what enables it, but what prevents it. It may deter non permanent members of the United Nations Security Council from insincere human rights claims as the pretext of military intervention. This point is compelling, as the provision measures effectively use them as condemnation of using force to prevent genocide. However, some aspects of the Genocide Convention and the decision may suffer from criticism. What must therefore become of this in the future? That is something that is anticipated under Article 9 of the Convention as well, that stipulates that the ICJ has jurisdiction over such matters and is involved in such disputes. From the Ukrainian perspective, the attacks were the result of the Russian abuse of exercise of the right to denounce and prevent genocide, clearly outlined in the Convention. The allegations of abuse of right take from a special force since Ukraine observes Russia distorted the scope under its right under the convention and exercised them from stark disharmony with the objectives and conventions that were placed. This view aligns with those considering the responsibility to protect which flows from intervention not as right but as a duty to the international community. This could complicate an interpretation of the convention. Nonetheless, the court chooses not to directly address humanitarian intervention. For the United Kingdom noted that the interpretation of the Genocide Convention is not required to engage in a broader analysis of international legality of use of force in response to grave humanitarian crises, including those under the doctrine of humanitarian intervention. The court may conclude that there were no proofs of genocide, thus negating the need for preventive actions. Although some may feel that avoiding these broader questions might seem like judicial omission, the court could still use the broader formula in its decision. The provisional orders, as expressed with skepticism, prevents the consideration of the convention with the aims and purposes that has, which authorize unilateral military force by intervention and prevention of genocide. The court seems to lean towards excluding unilateral interventions based on the convention. Whether such interventions could be justified under or other international norms is outside the scope of the procedure, which is confirmed under the convention. To conclude, what one can reflect is that the matter between Russia and Ukraine is not only fought in the International Court of Justice, but in other international forums and courts as well, such as the European Court of Human Rights, which has taken cognizance of the matter based on Russian submissions. But the question that is raised is the effectiveness of lawfare in armed conflict. Is it a strategic advantage or a risk to use international law? The swift action of Ukraine in courts in armed conflict is important, but these courts, including the International Criminal Court, have demonstrated a commitment to upholding these principles, but to a limited extent. Notably, these courts have responded rapidly, but lack the potency of an international force to imply their decisions, which force the international community's apparent resignation to the inertia may prevent the system of international law as a flawed one. However, the symbolic power of these judgments remain a significant step in international spheres, affirming the widespread condemnation of these attacks. With those words, I now thank the organizers for once again giving me an opportunity to share my thoughts and perspectives. It is indeed a pity for me to not be able to do this in person in Jersey, but I wish everyone in the conference and in the symposium the heartiest of best wishes and best luck.